All right, welcome everyone to our webinar today on photographers' rights, navigating copyright realities. My name is Rachel Kim. I am Vice President of Legal Policy and Copyright Counsel at the Copyright Alliance, which is hosting this webinar today. We're a nonprofit education advocacy organization based in DC, and we represent creators and copyright owners across the spectrum of creative disciplines and their copyright interests. And we're really excited to bring this copyright related programming to our photographer members today. And so if you want to check us out and our resources, we have a website at copyrightalliance.org and an individual creator membership, which you can sign up for free to stay up to date and engaged on copyright news and great webinars like this. We're also joined today by 21 other creator-centric organizations across the country who are co-hosting this event. And you can learn more about these organizations and their legal and supporting services for creators through this webinar, but also we'll be sending out some post-webinar resources where you can learn more about these organizations and our co-hosts. And today's webinar will also feature a Q&A portion at the end of the webinar with our very distinguished panel of experts. So feel free to submit your questions through the Q&A portion and function in the Zoom webinar. Or if you're watching from Facebook Live, you can submit your question in the Facebook comments. And one last note before we jump into the webinar, as I mentioned, there will be post-event communications and emails going out to all of our webinar participants, where we're also going to include a recording of this webinar. So if you happen to miss something in a particular moment and you're like, oh, what did they just say? Don't worry, it's going to be recorded and that will be made available after the event. So without further ado, let me introduce our panel of experts today. I'm really excited to have them join us and kind of talk about the different copyright issues and hot topics that photographers need to know about, in terms of their business and their craft. So we have Tom Maddrey today, who is the Chief Legal Officer and Head of National Content and Education at the American Society of Media Photographers. We have Alicia Calzada, who is the Deputy General Counsel at the National Press Photographers Association. And we also have David Trust, who will join us very shortly, I hope. Some technical difficulties, but we have David Trust, who is the CEO at the Progressional Photographers of America. So very excited again to have this webinar and have our panel of experts talk with us today and walk us through sort of the copyright considerations that a photographer needs to know about. So, let's just dive right in with the first question of kind of talking about the foundational concepts of copyright law and how that's really important for a photographer. So, Alicia, I'm going to ask you this one about, when does a photographer kind of own the copyright to an image? What steps should they take to ensure ownership of their works? Could you talk a little bit about that?
Thank you, Rachel, and thank you for the invitation to be here. It's a real honor to talk to people about my favorite topic, which is photographers and the law. So copyright, there's a lot of misconception around when copyright is created and how to sort of achieve copyright in a work. The reality is that according to US law, copyright is created the minute the work is created. The technical language in the statute is fixed in a tangible medium, right? So that used to be, the minute you write a book or the minute you make a painting or the minute you snap a photo and it's on a film. Digital counts, zeros and ones are tangible medium apparently. So fortunately for us, there's no question that's been worked out long ago. But the most important thing that people need to remember is that you take your phone and you go, take a picture, you own the copyright to it. And so a lot of people talk about copywriting their photograph. That's sort of a mistaken way of discussing it and approaching it. There's a couple of caveats to that, which is, sort of the defaults in who owns the copyright. So by default, if you are an employee, right, and taking pictures is in the scope of your employment. So let's say you're a newspaper photographer that's an employee of a newspaper. That's the traditional old, classic example. But there's all kinds of situations now where people are taking pictures for their job because every company that's imaginable is using photography in a variety of different ways. Well, if your job, part of your job is taking pictures, your employer actually owns the copyright. So that copyright is created instantly, but you're not the owner, it's the employer. Now, in contrast, if you're independent, if you're a freelancer, you by default own the copyright. So you take a picture for your client and there's no agreement to the contrary, you own the copyright to that work. And again, this is a situation where a lot of clients get confused. They think, oh, I paid you for this picture, so I own it, right? That is not the way the law sees it. Now, that said, you can change this status. And whether that's your relationship with your employer or your relationship with your client, you can give away your copyright by signing it away. In order to transfer your copyright, that has to be done in writing and it has to be signed. So you can transfer your copyright to your client, and people often do, either by doing something called the work made for hire, which treats the work just as if you were an employee, or just by doing an assignment of the copyright. Those are things that you'll find in your contracts. And that's why it's extremely important to use contracts and read your contracts. If your client gives you a contract, you can't just sign it. You have to read it because you have to know who owns the copyright in the situation. And if there's an expectation that it's going to be one way and the contract says something else, well, you need to have that conversation before you start taking the pictures and turning them into your client and stuff like that. So I always advocate for contracts and discussions about these things before you start the assignment. And just one more quick thing, which is that owning the copyright is separate from registering the copyright. There are great advantages, and those will be touched on later, but there are great advantages to registering your copyright with the Copyright Office. And most of those relate to if you have to enforce your copyright. So you don't have to register it to own it, but in order to enforce it, in most cases, you have to register your copyright in advance.
Yeah, no, thanks, Alicia. I think, like you mentioned, we hear a lot from creators all the time of, how do I copyright something? But to know that copyright is automatic once it's, fixed in a tangible medium, it has that minimal creativity. But then there are certain other considerations when it comes to thinking about, ownership issues. And really, thanks for kind of walking us through those considerations as well. I'm going to actually move to, a question kind of about other kind of legal concepts that that photographers need to be aware of. I think Alicia kind of touched on the fact that, even if your copyright is automatic, once the requirements are met, there's still a lot of benefits with registration, which we'll talk about a little bit later in this webinar. But Tom, could you walk us through some sort of legal concepts that maybe photographers need to understand or to know more about when they're actually registering their works with the U.S. Copyright Office? I know Alicia kind of talked about ownership, but are there other kind of legal considerations that photographers should know?
Yeah, thank you. And thank you for having us. I'm excited to speak with everyone again, like Alicia, about something that I get excited to talk about. The core of registering your copyright is first understanding exactly what Alicia was saying, which is you have rights to begin with, and you have rights from the moment you create that image. But if you want to enforce your rights, if you want to get the full benefit of the law, you do have to take that next step for registration. And because the Supreme Court has come out with some cases that have said, you can't file a copyright infringement claim until you have that registration in hand. And so registration, we definitely encourage registration as part of your workflow as a photographer. And it helps protect your most valuable asset, right? Your photographs and your creations. But when you get into that registration process, especially the first or second time you do it, you're going to run into some questions that you may not have run into before. So there are some legal concepts that you really want to keep in mind as you go through the registration process. And, some of them are very straightforward, right? It's going to ask you about who the creator of the work is and who's the person that should be contacted if there's a question about the work and things like that. But one big area that Alicia touched on is, who's the copyright owner? And if you do have one of those work for hire situations where, while the general rule is that you own your copyright when you snap the picture, there are certain circumstances where you may not be the one who owns the copyright if it is a work for hire agreement, which is why reading those contracts is so important. But I think the question that we get the most about the copyright registration process has to do with a few legal topics that even a room full of lawyers can't necessarily agree upon. These are things like whether the work is published or unpublished. So under US copyright law, for photography in particular, there's group registration applications where, all other things being equal, you can register up to 750 works at one time on a special type of application. But those applications are split into two groups, right? They're split into a group of unpublished photographs or a group of published photographs. And you might be thinking to yourself, well, I just have to decide if I publish my photographs or not. And I wish it were that easy, because publication and whether something is published or not published is not what we decide it is necessarily. It's what the US Copyright Office decides it is. And so they have a lot of rules and a lot of examples of when something might be considered published or unpublished. The core of that distinction, and again, I think over at ASMP and at all these various organizations, I'm sure we all had videos on this. I know that I do, hour-long videos on published versus unpublished. But the core is, if you're distributing your work out into the world for purposes of further distribution or display, then it very well could be considered published. Now, all of these things are important legal concepts, but I want to point everyone's attention to a case that happened just a few years back, and this is the Unicolors versus H&M case. The reason I bring that up, and this was a US Supreme Court case that talked about copyright issues, but the reason I bring that up is because in that case, there was a ruling that came down that kind of opened up a little bit our abilities, if we happen to make a mistake, our abilities to remedy those mistakes in the future. And so, without getting into the deep details of all of that, I'll say that you are now in a position where make your best good faith effort guess as to, after reading all the information and watching all the videos, whether something is considered published or unpublished. And you're probably going to have some latitude to be able to correct that if in the future it's determined that that's incorrect. That's just one example of a legal issue that you will likely run into when you have to make that threshold decision. Hey, I want to register my works. Which form do I use, right? Do I use the one for published or the one for unpublished? And I know that all of our groups have resources on that particular issue, among others.
Thanks, Tom. Yes, as you said, even when you get lawyers together in the same room, sometimes they can't agree whether something might be published or unpublished. But thanks for kind of walking our audience through sort of the different considerations in making that determination, but also giving that reassurance of, like, it's okay to make a mistake as long as you're making sort of a good faith effort to make that determination, because we realize that, your photographer is not going to always be a lawyer. That's not the case with our experts today, but we don't expect individual creators to make definitive, solid legal determinations. I think it's just do your best as you can on the registration. So thank you for bringing up that reassurance as well, as our photographers kind of think about the registration considerations. Okay, so we talked a little bit about ownership. We talked a little bit about registration. And I think what's common is that, both of these things are really important when you're gonna start talking about licensing and marketing and really conducting your business as a photographer. So David, I'm actually going to turn to you on this question. Sort of, could you talk us through sort of what are the different photo licensing options that are out there for photographers, or any considerations that photographers should keep in mind when they're thinking about licensing? I turn it over to you.
And Rachel, it's a great question because, and really, I think it's sort of fundamental to some of the problems that professional photography as an industry generally has, with the copyright system and the registration process. By the way, I do apologize. I was trying so hard to get in. You folks were trying to help me get in. I appreciate that. Thank you for the assistance, and I do apologize for showing up a little bit late. Yeah, I mean, to the question first, and that is there are a lot of different licensing models that professional photography uses. It's almost as diverse. It is as diverse, I guess, as photography itself, right? So I mean, there's rights managed, and which allows photographers to license their specific images and allows them to dictate how and where and when and for how long those licenses are going to be used. And I think that that's probably more typical with editorial and commercial advertising photography. Certainly, I think Alicia and Tom would probably be more suited to talk about that particular. Royalty free, I think, for our members. I mean, our members cross, all types of photography, but most are commercial, portrait and wedding and all types of portrait, all kinds of portrait, and a royalty free model that it allows the buyers, the consumer, to pay a one-time fee with some guidelines. Obviously, it's not wide open to use the image multiple times in multiple ways, without additional charges. And so, a lot of ours would be royalty free. There's exclusive rights, right, where the buyer gets exclusive rights to the image, meaning that you cannot license it to anyone else, at least during the time of the usage. And so exclusive rights would be, a model that a lot of photographers use. And then obviously the opposite of that, non-exclusive rights. You can license that same image, to multiple clients simultaneously. And again, I think that this would apply to much of stock photography in particular, but to all types of photography. And then one-time use, which is exactly what it sounds like, editorial use and for photography and commercial use. For our members, I think that most of our members are probably using a customized version of royalty free. That is to say, with each different client, or maybe their different business models that they are choosing a royalty free licensing system that then they customize based on what the needs of those consumers. And obviously that's really the issue in all of this, is that ultimately the consumer is going to drive the market. That is the same with every profession, every product, that's whether it's photography or anything else. Ultimately the consumer is going to drive the market, and that's the pressure that so many creators feel now, because consumers in some ways are trying to drive the market to places that the creators don't want it to go, right? And so that's kind of the angst that so many creators feel. But there are just so many different licensing models. And by the way, I think that that's worth just pointing out, that that's the issue, is that photography is so diverse and the business models are so diverse that it's really impossible to have a copyright system that serves everybody. We have for a long time sort of rejected that idea that there is a one size fits all copyright system, that there can't be, because of the vast variety of business models just within professional photography, but within the creative industries as a whole, right? And all of them are different. So there are actually a lot of different models out there, and then each one of those variations can be customized. So it's really up to the creator and what the customer's needs are. I'd love to hear, Tom and Alicia may have different takes on that, because they do represent generally different bases of photography. But from our perspective, it would be more a customized royalty free, for most portrait and wedding photographers.
You're right, David. And I mean, a perfect example would be, what a wedding photographer does versus an author who just writes one book, right? So your members are creating thousands of images in a day. So are mine, frankly. But then you have, someone who writes a book and it takes them 2 years and they have one work that they have to worry about registering and enforcing again, the copyright on. So you're spot on.
Yeah, I think that kind of tour de force through different kind of licensing models shows two things. I think one, just the importance of copyright law in general and its ability to afford that ability for your creators to have a diverse set of business models for exclusive, non-exclusive, royalty-free, et cetera. Just that's the copyright law is what enables kind of that freedom to market and license and meet your consumers' needs. But second, to David and Alicia's point about, needing to meet the needs of a diverse set of creators, even within the photography industry itself, of not, one photographer's business is not going to look like the others. And so how can we look at our registration systems and practices and our laws and regulations to ensure that we're meeting the needs of our photographers to register and also to help them enforce their rights when it comes time. And on that note, I guess jumping into and moving away from sort of the ownership licensing issues into the more kind of enforcement questions. I think I'm going to turn to Tom first on this, and then maybe Alicia, you have some thoughts on this as well. But what are some ways that photographers can address copyright infringement? We live in the age of the internet, and then with AI being explosive in the past couple years, I think copyright infringement and how to enforce effectively is something that's on every creator's mind. So Tom, could you walk us through maybe some of the options that are available to photographers?
Yeah, absolutely. And this is where we get to talk about something that I think all the groups, certainly I know on this panel, had worked for many years, and more than a decade ago, the photography associations, among others, worked hard to get passed into law and bring into existence a small claims copyright court, which allowed people to have a alternative to going to federal court when they had a copyright infringement claim. And a few years ago, that actually came to fruition. And it was a very exciting moment for ASMP and for all of the various groups. And hopefully it was a very exciting moment for photographers, because now you had at least an alternative to the multi-year, multi-$100,000 process of trying to bring your claim in a federal court. But what we have seen in the last few years is that this is, in my view, and I'll just speak for myself now, a wonderful idea that is still finding its footing, I think is fair to say. And the CCB, which is what it's called, the Copyright Claims Board, is this tribunal that we have been looking for all of those years. And you can go to ccb.gov if you found your work has been infringed, and you can have an alternative to try to pursue that claim. The three individuals who are on the tribunal are copyright experts. There's something about that is important, because you could end up in federal court and your judge may be a wonderful judge and not know the first real thing about copyright. And so you're dealing with copyright experts who understand your claim, and you're dealing with lower amounts. The entire amount in controversy at the CCB is $30,000 or less, and there's some micro limitations there as well, so you can even have a quicker resolution. Now, this is not all sunshine and roses at this point. We've heard from a lot of our members who have gone through the CCB process that it's taking a long time and it's hard to adhere to some of the rules, especially around service and getting the other parties involved and all of that type of thing. But I still remain hopeful, and I have certainly spoken with individuals and ASMP members who have gone through the process and had a successful resolution. Sometimes all you need in that kind of negotiation is a little push other than just you emailing someone, and that push can come in the form of filing a case with the CCB. there's a lot of benefits to it, and there's a lot of complexity to it. But the goal is to try to have something that is a simpler alternative to federal court where you don't need a lawyer. And the CCB was a big win for photographers and the creative community at large. And I certainly hope in the next few years it continues to improve and continues to help individuals.
Alicia, did you have any thoughts on sort of other enforcement mechanisms or processes?
Sure. Yeah, and you know, I think that the struggle that Tom was talking about with the CCB is flows from the fact that the law is complicated, right? That's why lawyers have really good life, you know, career spans. There's just a lot for lawyers to do out there because the law is complicated, and copyright law itself. You know, even though I presented some very basic points, and we're all sort of doing some really good deep dive overviews, they're really overviews, and there's just so much nuance in copyright law. And so, you know, some of these cases that are going into appellates, into appeal and up to the Supreme Court are so nuanced that, you know, if I try to, you know, write an article and send it out to NPPA members about it, most of them would just gloss over in the first paragraph. So I think some of that is related to the fact that just copyright law is you know, once you get past the basics, I own the copyright, you used my work, it can get much more complicated. The CCB is great for you know, very simple you know, situations like, you know, the person infringed. But you know, which thing you choose is in part based on your goal, right? So maybe your goal is just to quickly get paid what you think you deserve, and you and the other person can come into a fairly reasonable and quick conclusion or agreement on what that number is, right? So often the fight isn't about did you infringe or did you not infringe, it's about what's it worth. I see that a lot. If all you want is to just have them remove the work, which I would think that the people who have taken the time to log into this panel may want a little more than that, because hopefully if you're a professional, you really want to get paid for your work. There's something called a DMCA takedown notice. So if your work is posted online and it's a violation of your copyright, you can actually send a takedown notice to not the person who infringed your copyright, but to their ISP. And the ISP can be responsible for taking down the work. What that does is it creates a level of immunity. So because the ISP is like a publisher, they actually could otherwise be held responsible for also violating your copyright, but they get a certain level of immunity if they comply with this special little process called a DMCA takedown, which means that you write them, you say, you know, this is infringing, you know, this work is infringing my copyright, and then they're supposed to take it down. Now, again, this is one of these situations where in practical applications, we are seeing a lot of people who are getting ignored or getting pushback from, for example, some of the social media companies who claim that you know, that the photographer has to prove certain things or achieve certain hurdles that really don't exist in the law. So it's also not a perfect solution, but it's one way to do things, and it's also a good way to get the attention of the party that you believe is infringing your copyright, because of course, if they go to their page and it's taken down, they know something's up, right? And so that's also a way, if they're ignoring you, to kind of get their attention. And then of course, there's filing lawsuit in federal court. You know, this is can be very difficult. Most people do it with a lawyer. You certainly do have a right to file pro se, but for example, you know, just the cost of filing the lawsuit is hundreds of dollars, and then you have to serve, and then you have to do discovery, you know, and all that stuff. So it can be very time consuming and financially consuming. I think that when we were advocating for the CCB, there were some statistics out there about the average cost of a copyright case taken to trial was like $350,000. And believe me when I say that that's low. I mean, we have seen, you know, very I don't know if straightforward is the right word, but we've certainly seen copyright cases where litigating the case is $1 million, you know. The advantage to registering your work, which is what we were talking about earlier, is that if you have registered your work before it is infringed, or within a 3-month grace period of your first publication, again, you got to figure out the definition of publication, but if you've registered your work in a timely way, and you need to file suit, you can get something called statutory damages, which is a range that is, you know, a little bit less precise than needing to prove your exact damages, right? Because you don't just go to court and, yes, this person did me wrong. Well, let's just throw some numbers out there. That's not the way federal court works. You have to prove your damages, or you have to prove the other person's profits. And that can be very challenging sometimes, especially with something like licensing, which is usually based on 2 people who come to an agreement, right? So you have, when you give someone permission to use your work, and they have asked you for permission, you know, what you're going to charge them isn't necessarily the same as, you know, what your damages might be when you've when your copyright's been violated. So statutory damages really helps with kind of some of that nuance. And it also, you can get recovery of your attorney's fees in federal court. Now, the thing that lawyers will also tell you to think about before you think about filing a federal lawsuit is you can get a judgment for all the statutory damages and attorney's fees in the world. But if your defendant is not somebody who you could reasonably collect from, you have just wasted a lot of time and money and effort. So these are all things to think about when you think about, should I file in federal court or not? And that's one thing that the CCB also helps with, is it just kind of like, it takes down the sort of pressure of a typical federal lawsuit, which can be very, very stressful, you know, for everyone involved. So those are things to think about. There's also, you know, if you're a very prolific photographer and you have a lot of infringements out there, there are services that will help you crawl the internet, find infringements, and seek to enforce, you know, the copyright, or, you know, get licensing fees and stuff like that after the fact. So there's new solutions popping up all over the place, and we're hoping that the CCB does streamline and solve some of those more complex issues. And those are some different ways. I'll include a link to, we have an article on how to file a DMCA takedown notice on the NPPA website. So I will send that along with that package that they're going to email out afterwards.
Awesome. Thanks so much, Tom and Alicia. I think that gives our photographer audience like a lot to think about, I think, in terms of the different considerations that go into these different ways of enforcing, you know, your copyrights and fighting against copyright infringement. And really, like you both said, I think the CCB was a key part of that. We were missing for a while of those more straightforward infringement cases that are honestly a little bit too costly to bring them through federal court. So lots to think about for our photography audience, I think, you know, in terms of the different enforcement mechanisms out there. So thank you for kind of walking us through that process and letting us know of the different kind of options out there. So I want to move on to sort of a discussion maybe about the biggest copyright challenges. I think, again, you know, we'll talk more about generative AI too in this webinar, because what is a copyright webinar without talk of generative AI? But sort of putting generative AI considerations aside, David, I'll start with you first. Sort of what are the biggest copyright challenges that our photographer audience should know about today?
I mean, I think I think the biggest challenge is the registration system itself. For the longest time, we talked about problem 1A and 1B. It wasn't problem 1 and then problem number 2. Problem 1A was the lack of a remedy. That is to say that federal court for most infringements and most professional photographers is not a remedy at all, right? If you've got an $800 infringement, which by the way is very important to professional photographers, or $2,000 or $3,000, you're not going to federal court to try to recover it. And the consumer knew that. So the one who stole it in the first place, who infringed the work, when a photographer say, "Hey, you owe me this money," their response was, "Take me to court," right? And that happened a lot. And so, if nothing else, the CCB, the Copyright Claims Board, which to a lot of the people on this webinar probably just remember as the Case Act. The Case Act led to the creation of the CCB, right? And so, the creation of the CCB was a major victory. And the reason I feel like it still is a major victory is that yes, not everybody's going to the CCB. There's not room for everyone to go to the CCB. But I think now, just by virtue of what Tom had said, just getting a letter, someone filing something, or pointing out that we can go to small claims, that it brings people to the table. They can't just ignore photographers anymore. They can't just blow them off. And so the big hurdle was 1A was the lack of a remedy, but 1B is a registration system that is antiquated and unrealistic and really quite impossible, especially for high volume creators to participate in. It just can't happen. The requirements don't have a lot of reason behind them in the context of 2024. And some of the deposit requirements and the registration requirements and the requirement to sort published versus unpublished, as was pointed out earlier, for a photographer coming home at 10:30 at night, and I admit that I'm representing our members in this, but for a photographer coming home at 10:30 at night after shooting a wedding or a bat mitzvah or whatever, that night, and checking in on the kids, and then going to check on the images and going through, by the way, 1,950 images on average, that a wedding photographer will shoot on any given day, any given Saturday or Friday or Saturday or Sunday or whatever the day may be. That then checking on those images to make sure that in fact the data hasn't been corrupted, and then working on checking in on some things at 11 o'clock at night, 11:30 now, checking on some things for the job that they shot last week, and working on some marketing for the jobs that are coming up or that they hope to get, and then scheduling meetings and everything else. That for these one-man shops, that it is difficult. And so the difficulty of the registration process is, while some may say it's not that difficult, it is in fact. It's not that they can't figure out or learn the process, it's that they don't have the hours to do it. And so they're forced to decide, am I going to spend time working on my business, paying the mortgage and feeding my family, or am I going to spend time jumping through hoops? And so it is odd that, to me anyway, the most complicated issue, the most difficult issue when it comes to copyright in America is the registration system and the refusal to update that system, because it's not like we haven't been asking for changes for a long time. And so I think that is our biggest hurdle right now is 1B, and that is upgrading, changing the nature of the registration system in the U.S.
Alicia or Tom?
Yeah, I'll jump in and echo what David said, and then put some specificity to it, because our groups have worked collectively on a memorandum, a paper, which is currently being sent around Washington, the members of Congress, in meetings that our various groups have with those individuals, with the Copyright Office and elsewhere. And this is all about copyright registration modernization, to address some of the issues that we hear come up over and over and over again. We'll make sure that there's a link to this included in the packet afterwards. You can go to asmp.org and click on advocacy, and you can see it there in the orange banner. But I wanted to talk about this for a quick second because of some of the specific things that David was talking about, in this paper, which is ways that our groups want to have the copyright law either changed or amended, or the Copyright Office regulations changed or amended. We talk about things like getting rid of that published unpublished distinction in the context of copyright registration. We try to break down other barriers that are very limiting. one thing that that we've talked about and our groups have talked about for a long time is having subscription-based options, having ways that you can use technology and APIs to go straight from your editing software and register everything in a button press instead of going through the various hurdles and hoops that are currently required to get your work registered. And again, registration is important, because without registration, you can't enforce your rights to the fullest extent that you have them. And so it's very important to register. And I won't speak for Alicia and David, but I'll say I can't tell you how many times a week I hear from our members who say, yeah, I think that'd probably be a good idea, but it just seems like too much work. It's hard. I don't understand it. I don't have time for it. And that's what we're trying to remedy with our proposals on modernization. This affects every single creator, but visual creators in particular, photographers in specific, right? Because photographers, as you all know, create a lot of images. Alicia was bringing up the great point earlier: a photographer who comes home after a shoot with a given number of images versus an author who writes one book in 2 years. I think that copyright law should be able to apply to both, and the hurdle should be equivalent for both. And this is the type of advocacy that being a member of organizations like ours, frankly, helps support, because we're out there trying to make these changes to make the registration process easier, to modernize and update what currently exists, so that more people can recognize what their rights are and enforce their rights and have a career and protect their livelihoods. And there's benefit in that, not only to the individuals, but to all of society. And that's the core goal of things like modernization.
Right, Rachel, can I jump on something Tom just said real quick before we leave? On May 29th, 1790, the last state of the original 13 colonies ratified the Constitution. I think it was Rhode Island. I'm not sure. Actually, I'm pretty sure it was Rhode Island. On May 2 days later, the U.S. Congress passed the first Copyright Act. May 31st of 1790 was the first. It was important. Now, admittedly, they already had probably all of that sitting and ready to go, waiting for that ratification. But the point is that this was important. It was one of the first things that Congress saw that we needed to do once the Constitution was ratified. And they didn't do it, admittedly, just so that creators could get paid. The end result was the public good. And so it was so creators could get paid to incent them to create for the public good. Copyright is important to everybody. It's not just important to creators. It's important to everybody has a stake in this, and especially in the age of AI, right? And so we are the only country that requires registration of works before you get the protections, the full protections of the law that's associated with it. You have to register your works. And our feeling is that, look, if we have to register our works, then the United States has to provide a system that works for everybody, not just for some business models, but works for every creator. And it's not a suggestion. If you have to register your work, then the Copyright Office has to provide systems that work for everybody. They are absolutely obligated. It's not we'll get around to it, or maybe, after 20 years, we'll start working on this, or maybe it is. They are obligated to provide systems that work for all creators, very high value, low volume creators, and very high volume, relatively lower value creators. They have to create those systems. That's the reason I feel like this is number one. And it's not just important to creators. This is important to everybody. There's a reason it's in the Constitution, right? So I just wanted to throw that in. Sorry about that. Tom sparked something in me that just made me feel like we needed to add that.
No, I love what you said, David. As somebody who works with journalists primarily, we obviously care a great deal about the First Amendment and freedom of expression. And sometimes people try to tell us that the First Amendment is in conflict with copyright. But in fact, copyright is the engine of free expression. And so the Supreme Court has said as much over and over and over again. And so copyright is what enables people to go out and write books for a living and create cultural archives, and to beautify our world with paintings, and to educate us and tell us our history as it's happening. For journalists, which I love. I mean, just look at all the incredible images we're getting out of the Olympics. I mean, it's just mind-blowing and stunning. And, all of that is possible because professionals are doing this work. You don't see these incredible images you see out of the Olympics coming from people sitting in the stands with their iPhones. I'm sorry, you just don't. And so it informs us. Obviously, we have this election coming up. All of these things that inform our world and beautify our world and beautify our personal lives. Copyright is the engine of all of it. And so I just love what you said, David. Back to the question about, some of the biggest challenges that photographers need to know about in copyright, Rachel. I'm going to just lean in again to what I keep talking about, which is contracts and terms, and people need to read their contracts. That's a big problem I see, is people who fail to think enough and work enough on their contracts and treat their photography business as a business. These contracts actually are great for your business because they improve the relationships you have with your clients. And so contracts all the way are things you need to think about and work on. That's a very baseline issue, but you would be surprised at all of the professionals that neglect that issue. And the other thing I just want to touch on is there are some states and also the Federal Department of Labor that are talking a lot about what is the definition of employment. So this goes back to what we talked about in the beginning about who owns the copyright to an image you take. Well, it depends on if you took it for your employer. Well, how do you know if they're your employer? It depends on the definition of employment. So this is something that photographers need to continue to pay attention to, because the definition of employment can actually impact the definition of who owns your copyright. So I just wanted to throw that out there.
Thanks to all of our panelists for kind of walking through some of the biggest challenges, I think. Kind of what we touched on earlier, the importance of registration, the importance of needing to modernize that. I think you all kind of explained the issues really, really well. And then also, Alicia, from the business perspective, the biggest challenges to photographers, just contracts, like read your terms, build accordingly to what your customer needs and what you need as well. I want to move on to sort of a more specific copyright challenge in terms of generative AI technologies, because again, what is a copyright webinar without discussion of AI? So, for each of our panelists, I mean, I think this could be a whole webinar in and of itself, honestly. Just to talk about all of the issues that generative AI has brought up in terms of copyright law. But for our photographers today, could you share a little bit sort of your thoughts on how generative AI technologies have impacted the photography industries? Are there any steps or practical solutions that photographers should know about, or any kind of legislative actions that are on the table currently that you think our photographer audience should know about? So I'll start with David, I think. Yeah.
I mean, all of us are dealing with it, and all of our members are dealing with it. There are so many issues. First of all, AI is going to be useful. I think that people who are trying to work against creators and creators' rights are framing it in a way that makes it sound like creators are somehow opposed to AI, which is a little bit silly, because you can't be opposed to AI. It's in everything we're doing anyway, right? But it's also going to provide a lot of opportunities for really small businesses, 1 and 2 and 3 man shops, to do things they hadn't been able to do before in terms of managing their finances, doing their taxes, data mining, creating marketing campaigns, that are very specific, that are more effective, and it's gonna allow them to save time. And if you can put time back in a photographer's pocket, that's a major win, right? And so that AI is going to do that. Generative AI is a different story. It is going to have positive impacts, and there are some things that are good, and we have seen some interesting models in our sector of photography. The people that we spend time with, and the ways they're using AI, you know what I mean, to create product and to ideate and to find, to look for ways to do things and that. So there are some positives there. I think it's unfair that anyone who says anything negative about AI is anti-AI. I think you're allowed to be anti one problem in AI and not be anti-AI. And so yeah, I think generative AI, first of all, stole from all of our members. And I think that's uncontested, right? Nobody's even the thieves are not contesting that, and so we know that happened, and people are saying, well, that horse has left the barn, the train has left the station, whatever, however you want to frame that. I disagree. I just don't think so. I think Congress has all the ability in the world, and the administration does. And I think that there are ways for us to roll that back a little bit and force them to look more introspectively at ways that they can do things correctly. But the big problem for me is I'm not sure how Alicia feels and Tom feels about this. The big problem for, I think, our members is that they didn't just take their work. They took their work and now they're turning around and beating our members over the head with their own work. That they're creating things that are competing with our own members. I think nature wildlife photographers, if you're on this webinar and you're a nature wildlife photographer, you have all of our support, and it's an issue because AI is going to flood the world with fake nature. And all of us end up suffering from that. We are all poor. There's color that goes out of our world, right? Think of a beautiful, amazing image that you love, and you think, yeah, I would absolutely buy that. Now, think about that image, and if I said, "What's AI?" Would you buy it? And the answer is no, almost certainly no, because we're all human, and we don't put fake children on our walls, right? And so I think whether it's real or not real is going to be important to our world. And I think photography has a really important stake in the ground as the keepers of what is real. I think photographers are the keepers. And I realize there are other creators on this as well, but all of us represent photographic associations. So I think the problem with AI right now is that they're not being held accountable and they're being allowed to compete against our members with their own work.
Tom or Alicia, do you have any thoughts on this question? I'm sure lots of thoughts, but I think Alicia, you're on mute.
Sorry, thank you. You're correct. I've done an entire hour talk on, photography and AI and all of that. But so, NPPA's members are journalists. And so that is a very different AI conversation for us. And I'll start with this foundational concept, which is that your reputation is your most valuable asset. And in the journalism industry, AI is just not something that photographers use for their work, unless they're doing like a photo illustration, which we have been doing for decades, but it has to be clearly labeled as such, and it can't seem like an original photograph. Obviously, we're very concerned about deep fakes and those kinds of things because, not just the impact it has on miseducating people, but on the impact it has on the ability for people to believe what they're seeing from journalists, which goes back to the reputation point, which is that, you have to believe in the sources where you get your information. And part of that is the ethics that are ascribed to those particular journalists and the particular organizations that you get your news from. You have to rely on them. And so people really have to be careful about curating who they associate with in terms of their clients, but also where they go to and who they turn to for information. But a part of that is also that we have to think about, well, what is the line, right? Because it's my understanding that actually, if you take a picture with your iPhone, most of what the iPhone is doing is actually AI. And in Photoshop, you can do things in Photoshop that mimic what you would do in the enlarger, but they're done by AI. And when I say the enlarger, I'm talking about the darkroom days for those of you who are watching that have never had those days. But that's often been the standard for journalists. It's like, if you could do it in the dark room and it didn't, mislead, then it was generally, understood to be reasonable, without, unless it was just overkill. But now, what does it mean to use AI? And I think I'll punt a little bit to Tom on that question, because I think some of the things he wants to talk about, address that exact point, which is that, okay, if we're going to say no AI, well, what does that mean? What is AI, right? And where does it creep into our work? Those are questions we really have to be talking about as an industry.
Yeah, and I'll piggyback on what Alicia says, because I think it's important for everyone on this call who came to either is a photographer, is interested in learning about photography and the law and copyright, to be really thinking about how you're talking about it when you're operating your business as a photographer, how you're talking to your clients about it, because it's critical that you both are on the same page, and how you have to educate your clients as to some of the most important things that are going on right now. For example, it is pretty unequivocal from the U.S. Copyright Office that generative AI, entirely generative AI-based images are not given copyright protection. And the U.S. Copyright Office has also said that if you're using generative AI in the creation of your images, you have to disclose that and disclaim that on your registration. It's a whole separate issue that is of major concern to photographers, because you can't make those disclaimers. You can't do that on these group registration forms that photographers is really the only feasible way for a professional photographer to register their work. That brings up a whole host of issues in that direction. But let's go one step further down the path Alicia was going. If you're using tools that are utilizing generative AI underpinnings in them, you need to know that in case you have to disclose that, because the tool itself is now something that's creating enough of an image, enough of a part of an image that would require the U.S. Copyright Office for you to disclaim that to the U.S. Copyright Office. That's really tricky, because 2 years ago, we didn't have to think about that. And now we definitely do. And as we see technology moving forward so quickly and evolving so rapidly, guess what never keeps up with technology? The law, and certainly the Copyright Office and Congress and government. We're still operating under the Copyright Act of 1976. Now, it's had a few amendments since then, but you get the idea. And let me give a very specific scenario. I just said a minute ago that the U.S. Copyright Office says they're not going to grant copyright protection for images that are created with generative AI, and you have to say, hey, parts of my image that were created using that aren't covered, don't get that copyright protection. But does your client know that? And so for many of our members who work with large brands and companies, they hire you to do a photo shoot. You use certain tools that have generative AI underpinnings. You don't disclose that to your client. The client goes out with a national, international ad campaign, and suddenly someone is using the images that you took, and they're saying, okay, great, well, we can go after them for copyright infringement. But you can't, because it wasn't protected in the first place. And I can't think of a more direct line for a photographer getting sued than to have a client who isn't able to protect the images that they paid for you to create. And that's why it's so important right now, as things continue to evolve, that you take a real hard look as to what's in your contracts. Do you have clauses in your contracts that talk about these issues? Do you have clauses in your contracts that say, the work I create for you, client, is not licensed for AI training libraries? That's something that we're putting in quite a few contracts now over at ASMP. And are you educating your client on how copyright law is interacting with generative AI? Because a lot of clients want to jump on this bandwagon, and they're saying, hey, let's use generative AI in this way and that way and this way. Well, it's part of your job to help them understand that they won't have the same intellectual property protection that they would have in other contexts. Now, admittedly, a lot of this is still up in the air because it's so brand new. And so things are going to change not only every month or every year, but every week right now. And it's real important to stay on top of these issues, not only for your general understanding of the law and photography, but specifically for your businesses and your careers, because it's going to touch every part of what you do.
Awesome. I mean, that was like the most truncated you can ever get on GAI issues, I think, in the photography context. So thanks to our panelists for kind of talking us through the different considerations, everything from copyrightability to infringement to sort of the legislative priorities that Congress could be looking at. So, I know, Tom, you mentioned at the very end, like, this is why it's important to stay up to date on copyright issues, on copyright news. And again, as I mentioned in the beginning, you can do that with the Copyright Alliance. We send out, a creator newsletter every month, keeping you informed on copyright issues. And again, our creator membership is free. We have FAQs, Copyright Law Explained. But for our panelists, if we can go around the horn and just very quickly kind of talk about, like, how can photographers be more engaged and stay up to date on these issues, and all the wonderful work that y'all are doing as well.
For our members, quite honestly, in fact, for most people, and I think most photographers, when I say most, I mean, I really do think the vast majority who are participating in the system, copyright's kind of like the water fountain. You don't really care where the water came from. You just want the water there when you really need the water, right? And so for our members, it's a lot like that. Well, I think that photographers, as the system improves and as the registration processes improve, that photographers are going to have to acclimate themselves to registering their work, right? So I think that they need to be actively involved with their associations, and kudos to the Copyright Alliance for putting all of this together. Rachel and Keith and everybody, Eileen and everybody there, thank you for all of that. But stay in touch, stay informed, and be ready to act when we need them to act. To try to implement some change. But more than that, I think they need to start shifting into a mindset of caring. They care, but to change that into action, with copyright, and to start being more actively involved and aware of copyright and copyright issues, because they have to own it if they can to sell it. And so they have to make sure that they're protecting it. I'll stop there.
All right. Tom?
Yeah, absolutely. I'll echo a lot of what David said, especially with respect to the Copyright Alliance. I think you guys do an excellent job, and everyone here, if you're not a creator member, you definitely should be a creator member of the Copyright Alliance. You also should be a member of ASMP. I think that's wonderful to say, and NPPA and PPA. Our different organizations come together on these issues to fight for copyright, not only for our members, but for the industry as a whole. And I think that's one of the best things that you get about being part of a membership organization, is that ability to have a voice that's bigger than yours can be individually. Over at ASMP, we're really proud of a lot of the things that we've been able to build, including our Tuesday business and legal clinics, where we'll sit down and talk for 15 minutes one-on-one about what's going on in your world, right? And the challenges that you're facing. And that's where so many of these issues came up for the first time, where we have photographers who are running into these contract issues and these AI issues and these copyright issues. And so definitely, get involved with the various organizations and the Copyright Alliance, and stay tuned, because things are changing incredibly rapidly. And when we're in these early stages of lawmaking, when it comes to AI, I think that it's not out of the realm of possibility that you go to sleep one night and you wake up the next day and some law has been passed that really fundamentally shifts the way you need to be thinking about your business and your photography. I think we're going to provide in the packet after the fact a discount code for anyone who's not a member of ASMP. I know that some of the other groups are as well. And so please come join us. We do a lot of work on this front, but more than anything else, I'll echo what David said. Stay involved, stay educated, because this is the core of what you do. The more that you know about this, and the more your voice can be heard when it really matters.
Excellent. And lastly, but not leastly, Alicia.
Yeah, those are all great points. And you know, I think a lot of people think of trade associations as something that they need at the beginning of their career as they're trying to figure things out. Maybe they need a mentor, maybe they need, you know, some basic information, you know, workshops, that kind of thing, all of which NPPA provides. But, you know, I think that the AI world is a perfect example of how, at least within the news photography business, and which is ever shifting the definition of what is a photojournalist, and what we are doing is constantly shifting, you know, to the point where no matter your place in your career, you need to be able to keep up on these things, and we keep up on these things for you, so that when you have a question, you know, I think it's really amazing that you can pick up the phone and get me on the phone if you're an NPPA member, and you can ask me these complicated AI questions or complicated registration questions, and I can help you, you know, and I know the same is true with the other groups. And so I think that's a very valuable thing. I hate it when someone asks me a question and I can't help them because they're not a member, you know. And then the other thing I want to say about sort of that and the trade organizations is that, you know, a whole lot is going on behind the scenes that nobody ever knows about. And one of the most amazing things that's going on behind the scenes is that, you know, all of our groups have been working together for decades because we figured out that we're stronger when we speak with one voice. And so you may be a member of one of these associations or the other, or even during different parts of your career, different associations. My husband's a perfect example. He's been an NPPA member for decades. He just retired from his newspaper job, and now he's a PPA member. Because of some of the things that he wants to learn about and know about from that group. But back to my original point, which is that all of us cooperate and work together. We meet on a regular basis. We talk. Sometimes there were times when we were talking every week. We would get together and talk. So now we kind of like, you know, we don't always have that much going on every week, but, you know, every month or every few months, and we meet every year in person to discuss sort of our common interests. And that we don't agree on everything. When we disagree, we you know, we concede that we disagree and we go our separate ways on that issue. But there's so much that we work on together, and I love these guys. And it's such a pleasure to work on this stuff. But I think people need to realize how much is going on behind the scenes on their behalf with the Copyright Alliance and with other trade organizations. And I think that alone is a reason to support these groups and just to stay in touch with all of us. So I'll get off my soapbox now.
Oh, fantastic, fantastic. Thanks for all our panelists for sharing on how creators and photographers can keep up to date on all of these issues. Like you all mentioned, copyright law is always cutting edge because it always intertwines with the technologies of the time. And so it's really important to stay informed and to stay involved because it really implicates your rights as a photographer. And so, you know, thanks to our panelists for walking us through sort of the copyright photography landscape, doing a little bit of a bird's eye view. But now I want to get a little bit more specific with some of the Q&A. I know we don't have that much time left, but I will take a little bit of moderator's prerogative and go a little over because I know we started a little bit later. But we do have some Q&A from the audience. So the first question I'll pose to our panelists, and you know, anybody can feel free to jump in and answer. One question we got from the audience was, do I have to register my images? If yes, how soon after an image is taken? What are photographers' rights if an image is not registered? And I think this is, you know, if there's an infringement, what are the rights in that instance?
One of the things I tell people when they call me and say their work has been infringed, but it's not registered, is register it. Because if it's been infringed once, it's going to be infringed again. And regardless of how you're able to enforce your copyright with that particular infringement, you at least want to, you at least are now on notice that this is an image that's likely to be infringed in the future. And so you want to put yourself in the best position to at least continue to enforce it in whatever way you can, and you'll be in a better position if you register it then.
And, building on what Alicia's saying, the idea is that if you register that work before it's infringed, you get a lot of additional benefits, right? You also, on a very, as Alicia said earlier, within 3 months of that first publication, you get those additional benefits as well. But you could have taken the picture in 1980, and if you register today and it's infringed tomorrow, you've done what you need to do to get all the rights and all the enforcement mechanisms that you have available to you. So yeah, definitely get your work registered and put it as part of your workflow. Figure out how it works for you in your business. We all have members who are in totally different areas and have different numbers of images that they take, but there's a way to fit this into your workflow to give you the most protection.
Awesome. All right. So we have another question from the audience that asks, if you have a business, is there a way to get a blanket registration for anything generated by that business? So I guess all the photographs that that business needs to register, is there a streamlined way to sort of register that with the Copyright Office?
Well, you've invaded our dreams.
Yeah, yes.
That's exactly what David was talking about earlier. We are really trying very hard to make this easier. At the moment, no, you have to register each photograph individually. Well, each photograph either counts towards one of those 750 in the group. But we are continuing to try to make it more streamlined, and wouldn't that be wonderful?
It is worth pointing out that you do need to register your work before the infringement, except, and that's the value of the Copyright Claims Board, is that you can file that small claim. You are giving up damages and other things, other money that you can collect, but you can still collect some and you can get paid for the work that was infringed. And so you can register. You can do that after the fact, after the infringement, with the Copyright Claims Board, right? So don't just say, wow, I didn't register it and I'm gone. You can send it to the Copyright Claims Board, then send that letter to the infringer and convince them that it's going to be a lot easier to settle with you than it is to, go through the copyright claims process or even federal court. So, I mean, there are advantages to that.
Yeah, no matter what forum you're in, whether it's the Copyright Claims Board or federal court, you can always get those actual damages, just not the statutory damages that Alicia was referring to. And so, as Alicia said initially, and as David, correctly notes, if your work has been infringed, get it registered. I mean, get it registered. You don't say, oh, it's too late. I'm too late, because you do have options there, and the CCB is a new route.
The best time to register your work was before, and the second best time is now.
Well said, well said. All right, we have another question from the audience that asks whether our panelists can speak to YouTube fair use considerations, but thumbnails in particular. I think this is a really interesting question. I guess just walking through, I think this is in the context of probably like a DMCA notice and takedown of like, oh, you see this thumbnail, it's my photograph. Who do I reach out to? Do I need to consider fair use while I'm sending that notice and takedown? Yeah, whoever wants to take this one.
Yeah, in fact, you are required to consider whether it's fair use before you send the notice, the takedown notice, which is interesting because judges disagree on whether a particular use is fair. I mean, the fair use is like a continuum, right? Some things are clearly fair use. And, that would be like, oh, here, an article about this photograph, right? We're talking about the photograph. You can publish the photograph so that you can discuss it. That's fair use. But over here, things that are clearly not fair use. So the questions are about the things that are kind of in between, and you're probably not qualified to decide whether something is fair use or not. So again, just to, make your best determination based on the 4 factors.
Yeah,
Oh, sorry, go ahead, Tom. No, please.
Well, I think fair use is one of those things, as Alicia said, where there's no bright line rule as to what's fair use and what's not. It's a balancing test, and we just had a very critical court case come out last year in Warhol versus Goldsmith, and which in very positive ways constrained some of the elements of fair use that were being, in my opinion, most abused, right? And so, what I always think about, though, when someone says, oh, it's fair use, it almost is never fair use. The person who's saying that is saying that to get out of copyright infringement. That's what I see all the time, right? And so, I think that you don't know if it's fair use, but do make that good faith effort. Do look at some of the recent court cases that have come out, like the Warhol versus Goldsmith case, when it comes to transformative use and how that plays into the mix. But there was an amicus brief that we wrote, and I think all our groups signed on to it. And Steve Doninger came up with a wonderful first line about what's the use. How you use it. If fair use isn't a binary, it is or it isn't in all circumstances. It's about how things are being used. And so it's hard to make a determination about a YouTube thumbnail. It really depends on how you're using it. If you're using someone's YouTube thumbnail in order to put it as a YouTube thumbnail on your video, then it's not fair use. But if you're using it to talk about how YouTube thumbnails have really changed throughout history, then it could be, because it could be commentary critique.
And Rachel, I would just offer that you hear, Alicia and Tom talking, and for a lot of people on this, your head is probably spinning a little bit, thinking, wow, how do I know this? And where do I begin? And how does this, and to me, that's the problem. The group that we refer to regularly, this group of visual arts associations, organizations, that we've been together for so long and we've worked together, it's 85%, maybe 90. It's 85% really smart, level-headed lawyers who know their stuff, and then there's the rest of us that are in the group. And I mean, so I look at this the way maybe a lot of you are looking at this, in that this is like a different language. I've been rubbing shoulders with these guys for decades, and it's still very much like a foreign language. That's my point, is that this system should not be serving itself. It's a system that sort of serves its own processes rather than serving the vast array of business models and individuals out there who deserve copyright protection. Why? Because this country says you have to have a registration, basically, to be protected. And so that's part of the problem. Your questions, I know that a lot of people must be thinking, wow, this is too complex. We get it. And that's the stuff that we're trying to solve as each individual association, whether it's Copyright Alliance or NPPA or ASMP or PPA.
I think I'm going to wrap up the questions with that final one. So thank you so much to our panelists. I think it is a doozy to kind of talk about all of these legal concepts and legal language, but hopefully we were able to open some doors and some curiosity for our photographer audience today to learn more about copyright law. And again, as our panelists mentioned, you can do that through all of these great photography organizations. You can do it through the Copyright Alliance. And as a reminder, a recording of this webinar will go out to registrants of this webinar. Stay tuned for that, and also a recap blog. So with that, thank you so much to our panelists today for all of their insights and expertise. And, we're really excited that we had so many participants today. Thank you so much.